Hello, my name is Stacy and I am the Women's Law Legal Director. I've been with the Women's Law Project for about 13 years, and before that I represented victims of abuse in family court, integrated domestic violence court, and before that I represented low-income tenants in housing court. So enough about me. Today I want to talk to you in this online information clinic about some basic definitions related to custody and a court overview regarding the custody process. So there's a difference between what's considered legal custody versus physical custody. Legal custody refers to the right to make important decisions for your child, such as where your child goes to school or what medical treatment your child should get. And even though I will continue to use the term legal custody for this video, it's important to note that the laws in some states may call it decision-making authority, parental responsibility, or some similar term. Physical custody refers to the right to have your child live with you most of the time. And again, the terms might be a bit different from state to state. So some places call this parenting time or physical placement or something else. However, I will continue to use the term physical custody during this online information clinic. Joint legal or joint physical custody means that these rights are shared between the parents. So joint physical custody is when the parenting time is split between the two parents. Sometimes it's split evenly, and the children will go to each parent for a week at a time, or it might be 3 days, 1 week with a parent, and then 4 days the next week with a parent, and back and forth. However, other times it means the child lives with one parent for the majority of the time, and the other parent gets every other weekend, or perhaps sees the child over summer break and school breaks. It really depends on the situation, how joint physical custody gets divided. Joint legal custody would mean that the parents would have to consult one another on major decisions about the child and ideally reach some sort of consensus or agreement. Sometimes one parent is granted decision-making authority in certain areas of the child's life, while the other parent has authority over the other areas of the child's life. So for example, one parent might have final say and decision-making powers over where the child goes to school, including religious school, and the other parent might have that power to decide medical issues. Or the parents may be ordered to try to come to a decision jointly, but then sometimes one parent is given the final decision-making power if the parents can't agree. Sole legal or sole physical custody means that just one of the parents has these rights and responsibilities. Sole legal custody allows that parent to make decisions about the child without consulting with the other parent. Usually, though, the parent with sole custody might still be expected to keep the other parent up to date on major changes in the child's life, if it's safe to do so, if that communication is safe. If there's a no contact order between the parents, for example, or it's not safe to communicate for another reason, then there may not necessarily be this expectation of keeping the other parent up to date. Sole physical custody is where the child lives primarily with one parent instead of the other, and that parent is considered the custodial parent. The other parent might have their own parenting time, often called visitation, as I mentioned, and that parent is often referred to as the non-custodial parent. Let's talk a bit now about visitation. When one parent has visitation, they have the child in their custody for that specified period of time. And what the actual visitation schedule looks like is going to depend on the circumstances, like how far apart the parents live, what their relationship is like, and what the judge believes is better for the child. And whether or not the visitation is spelled out in a detailed way or left up to the parents to decide, is often determined by how well the parents get along and communicate with each other. Parents could decide to set up a strict schedule that plans out where the child is each day during the year, or they can leave it flexible. Parents often will agree to each have the child on alternating holidays and will even divide up the child's birthday about who gets to spend time with the child on their birthday, whether the day is divided or the parents alternate each year. Visitation agreements can lay out the parameters for the child's vacations, including whether either parent can take the child out of the state or out of the country, and even at what point either parent can introduce their child to a significant other. All of this can be negotiated between the parents and written into a visitation and custody order. Now, it's good to understand that while a parent has visitation with their child, they can make some of the day-to-day decisions for that child, even if they don't have legal custody. So, for example, let's say during visitation, the parent can decide who the child spends time with, what the child eats, when the child goes to sleep, things of that nature. Sometimes the fact that the non-custodial parent can make these day-to-day decisions causes friction between the parents. So for example, let's say the non-custodial parent decides to take the child for a haircut during visitation time. This could anger the custodial parent if they were growing the child's hair out or they like the child's hair to stay long. And courts are not likely to get involved in decisions like these that parents make during their visitation after the fact. So if you fear that the other parent will make decisions during their visitation time that will upset you or potentially harm your child even, you may want to try to include a list of parameters or limits in the custody order as to what the non-custodial parent can do with the child. So for example, going back to the haircut example, you could ask that it be included in the order that the child only gets their hair cut or decisions regarding, let's say, ear piercing or other appearance-related decisions shall remain with the custodial parent. Now, I can't say for sure whether or not a judge would allow this to be included, especially if the judge is designing the custody order pursuant to a trial. But if you're going to be settling the case and agreeing upon terms of the order with the other parent, it could be worth a try, if this is important to you, to try to get some of these limits included to prevent issues in the future. Now, as I discussed earlier, the custody order may also spell out how visitation exchanges are to be made. So if there's no domestic violence, for example, and the parents have a workable relationship, it may be that the order only says visitation exchanges are as agreed upon between the parties. So that's really lenient, very open-ended. However, if the parents' relationship is difficult or if there's a no contact order due to domestic violence, then the visitation exchange may have to be very structured, even down to the minute. So for example, an order could say that visitation will be from 5:30 p.m. Friday afternoons until 5:30 p.m. on Sunday afternoons, and that the exchange of the child will take place at the police station or the local McDonald's or the grandmother's house or some other very specific location. In some situations, when the child is not safe with a non-custodial parent or the other parent is not safe being around the non-custodial parent, the judge could order supervised visitation or supervised exchanges of the child. It's very rare that a judge would deny visitation entirely. It does happen, but it's in extreme circumstances usually. Supervised visitation could be a temporary fix, and often this becomes unsupervised if the visits occur without incident. Now again, this is going to depend on the specific situation, whether the visits are a short-term temporary fix or whether the judge puts supervised visits in for longer term. Supervised visits could take place at a local visitation center where they're monitored by professionals who write up reports of the observations and give them to the judge, or they can take place with what's known as a third party, so someone else aside from the parents. This could be a grandmother or a cousin or someone who's supposed to watch the parent and child interact and be with them at all times during the visitation to make sure that nothing happens to the child. Now, even if the visits aren't supervised, there could still be supervised exchanges of the children at a visitation center, for example. But oftentimes there is a cost to use a visitation center for exchanges or even for supervised visits. And that cost might be ordered to be split between the parents, or a judge could divide it up in a different way. So this is something to consider when you ask for supervised visitation. Now let's switch gears for a moment and talk a bit about how judges decide custody and visitation orders. Usually, judges prefer joint legal and or joint physical custody unless there are extenuating circumstances that require another type of arrangement. So for example, if one parent has committed domestic violence against the other parent, the judge may decide not to give that parent joint custody. And again, we'll talk more about how domestic violence can affect custody in the third online information clinic in this series. Now, when there's a custody case going on in court, often the parents will come to a settlement and agree on how to divide custody. However, if they can't agree and it goes to trial, a judge will usually make decisions about custody based on what they believe is in the best interest of the child. This is a common term that you hear in custody cases, but simply put, it means that the judge will be deciding what services, orders, and custody visitation arrangements will be best for the child. So for example, the judge could consider factors such as which parent could provide emotional, economic, physical stability, which parent will promote a healthy relationship with the other parent when appropriate, where the child has more social ties, family ties, who will provide better educational opportunities and stability to the child, and any history of child abuse or domestic violence. These factors will vary by state, but I just wanted to give you a few examples of ones that are commonly looked at. So most states, as I said, have their own specific list of things that the judge has to consider in terms of the best interest factors. And these are spelled out in the law. You can find the list of best interest factors that a judge will consider in your state on our womenslaw.org website. So to find your state, you would go to www.womenslaw.org. And then on the top menu, you're going to click on the Legal Information tab. Then you're going to go to the Know the Laws by State section, and then you scroll down to Custody. If you haven't already, you'll choose your state from the menu. And then when you're in the Custody section, there will usually be a section called the Custody Process or something similar to that. And within that section, you'll see a question called, how will a judge make a decision about custody, or something similar to that. You can also find this information in Spanish on 26 states, and we're increasing that all the time, so more states to come. The judge could also order a court-appointed social worker to visit each parent's home, often known as a home study, as well as social and psychological evaluations, which are often called forensic evaluations. The judge could even order drug tests of one or both parents if she thinks or he thinks that it's warranted. And we will go into more detail about this in the second OIC custody OIC in this series. Now, in most circumstances, custody is given to one or both parents. That's why I've been just using the word parents. But I do want to mention that it's possible custody could be given to someone other than a parent. Usually this is when the parent or parents are considered to be unfit. In that case, another adult could be given custody if they apply for it, such as a grandparent or someone else close to the child. But it's a very hard standard to meet to prove that a parent is unfit. Oftentimes, this happens if a parent is addicted to drugs or something similarly serious where the judge feels they can no longer have custody of their child. Now, let's talk for a moment about what happens if a custody agreement is not followed. If the parents decided not to go to court and instead they chose just to make an out-of-court agreement, then there's not so much that they can do if the other parent doesn't follow that out-of-court informal agreement. At that point, one of the parents may then need to file a case in court so that a court order can be established. In fact, once there is a court case, the parents can even ask the judge to incorporate the terms of an out-of-court agreement that they came up with into a court order for custody. But in any case, once a custody order is issued, it's supposed to be followed by both parties, or else one of the parents can file a violation petition asking that the other parent be held in what's called contempt of court. And in our next online information clinic, we will go into more detail about the options that a parent has if the custody order is not being followed. Well, thank you for joining me today for this online information clinic. I want to also invite you to visit our website, womenslaw.org, where you can find other online information clinics on other topics. And you can also write to us on our email hotline, which is a confidential and anonymous way to ask legal questions related to domestic violence, sexual assault, or stalking. The email hotline is available in English and Spanish, and it's staffed by attorneys, including us, including me, on the Women's Law team. Thank you again for your attention, and have a great day.